And just in terms of situations where you might come across where you would want to get consent, potentially as learning disabilities, talking about the learning disabilities of a student in the Head Start program. Are you within the exception, or have you obtained written consent to disclose that information? Or potentially family circumstances, things that are going on with that particular family if they're part of the student education records, and that is not something that can be disclosed or shared with anybody absent written consent, and then also within the scope of that written consent. Yeah.
So I want to take just a minute and break away from that to point out that this is not a theoretical discussion. Denise, come here. Some of you don't know Denise Ortiz-Campbell, but Denise is one of my heroes at the moment. Because last year, we had a very angry cop show up at our Head Start site in Prineville. And he demanded that Denise hand over a student folder. And Denise refused to hand it over. And he told Denise, I'm going to put your hands behind your back and put you in handcuffs, and I'm going to haul you away. And Denise faced that moment when she decided what those records were worth. And Denise said, I got to call my supervisor, and you're not getting the record. Which is exactly the right response in that situation. So you have the opportunity to be everyday heroes. I hope you don't ever get one of those opportunities. Denise will just as soon not have that opportunity, but it does come along, and somebody did the right thing there. So thank you, Denise.
So the consequences, so a student or parent has the ability to file a complaint with the U.S. Department of Education, and if a violation is found, Neighboring CAC could lose its federal funding. So the consequences are severe. You don't want to lose your federal funding for Head Start. So it's important to take that into consideration. And so also, as I mentioned before, whether or not the law protects particular information, we still have an expectation of privacy. Under our Constitution, under the laws, everybody has a reasonable expectation that their personal information is not going to be shared with other people absent their consent and authorization. And there's a couple of claims, and they're tort claims, public disclosure of private facts or information, defamation, and these are serious claims. These are tort claims. You can be subject to damages and punitive damages. So just always keep that in your mind when you have this information. Should I really share this? Should I really pass this on? Even if I care about this individual, is this appropriate? And if in doubt, don't do it. So what does this mean for you? Just a few tips. Always obtain written consent before any disclosure of protected information is made. Limit disclosure to those who only absolutely need to know as part of their job duties. Be careful who you include in communications. Don't forward to those who don't need to know. Keep files or documents containing protected information segregated and under lock and key. Don't leave them on your desk in public view. Don't leave them sitting on the fax machine or the scanner. They should be in a folder, in a file cabinet, preferably under lock and key, so we are protecting the security and integrity of that information. Don't use email to discuss protected information unless it's encrypted. Under the HIPAA rules, you cannot use electronic devices to transmit protected health information unless that information is encrypted. Same with faxing. If you're going to send a fax that contains protected information, send it only to a confidential fax. Call ahead. I'm sending you a document. And similarly, if you're receiving it, make sure it's sent to a confidential fax and it's not left sitting on that fax machine for long. Shred it. When you're done with it, shred that protected information. Don't throw it in the garbage. Don't throw it in the recycling bin. Again, that could be potentially inadvertently disclosed. Somebody pulls it out. So the best advice is to shed it. Don't share protected information with your family or your friends or your coworkers unless they absolutely need to know. Don't ask staff or other board members about protected information that you have no business knowing. Don't repeat it. If you receive it, don't repeat it to others, again, unless they have a legitimate and absolute right to and need to know it. Also, be care of auditory privacy. You don't want to be talking about this in a public place where it can be overheard. Be sensitive to that. Do it in behind closed doors in a private office so people can't inadvertently hear it or eavesdrop on what you're talking about. Also, it's important, I think your clients have a reasonable expectation of privacy too, and so you should not disclose the names of our clients or the services we provide to them without their consent to anybody outside the organization. So, Scott brought up a good issue. You may, in the course of your duties, have the police arrive demanding records, or you may receive a request from records from some party who may or may not be entitled to get them. You may receive a subpoena in the mail or through personal service. With respect to third parties, the general rule is we're not going to disclose anything to a third party without a subpoena. And that would include the police, that would include many public agencies. So if you get that request, either through a subpoena or through an outside request, definitely don't go it alone, contact your manager, and certainly if you receive a subpoena, usually there's strict timelines to comply, to get that to your manager right away, so we can assess whether it's appropriate to produce those records in response to the subpoena and what the next steps will be. But as a general rule, we're not going to disclose records to third parties outside the organization without a subpoena.
I have one question. Go ahead.
We've had child welfare agencies come in and cite a statute that allows them to have access to our records. Do we need a subpoena from them, or how does that work with that statute?
The question is, you get a request from a state agency who has enforcement authority over neighbor impact. Generally, those state agencies do have the power to receive those records. Normally, though, we want a written request citing the statute that gives them authorization to seek those records, and if they don't have that, then we'll want a subpoena. The subpoena does allow a little bit of cover in providing us records if you're being compelled by law to produce that information.
And that was the same question.
Okay. So I'm going to move on now. Yes?
I have a question about email and like within the agency, because a lot of times we are emailing, we use numbers for children, referencing things, asking questions, different statuses. Is that appropriate within the agency, or do those emails all need to be encrypted as well?
If it's personal health information, it needs to be encrypted. If it's just about a student and it doesn't involve health information, then no, but I think you do not want to identify the child by name. Use some other identifier that will be difficult to connect to them except for what you know. And obviously limit distribution of that email to only those who absolutely need to know that information.
Let's kick that to our IT director.
Transmission of email internally is encrypted by default. Second you forward it outside the agency, we lose all control over encryption.
Okay.
Unless we have internal. Internal email is encrypted by default. When you forward it outside the agency, we lose the power to encrypt the email unless a partner who we've already set up encryption between the two parties. So as long as it's internal and you don't print it or leave it open on your public computer, you should be fine.
Can you repeat that because they didn't hear it back?
An internal email is encrypted, but once you send it to an outside third party, it's not encrypted. So once it leaves the agency, you lose control over it, and it's not encrypted. So I'm going to move on to harassment, and just talk briefly about harassment in the workplace. Neighbor Impact, like most employers, have a policy prohibiting unlawful harassment in the workplace. This policy and the law also prohibits any harassment based upon membership in any protected classification, and that includes not just sex, but race, national origin, religion, disability, sexual orientation, military status, etc. So any harassment because of membership in any of those protected classes is unlawful, and it's also a violation of neighbor impact policies. A lot of people think about harassment just in terms of sexual harassment, but it's much broader than that. It can, and certainly in my practice, it goes way beyond now just the sexual harassment. It's also actions or statements that show hostility or adversity towards membership in a protected class. It's derogatory comments towards people in a protected class, or it's adverse treatment of people in a protected class. So it's much broader than a lot of people understand. It also doesn't just cover male on female or female on male harassment. It also includes same-sex harassment, and we're definitely seeing a rise of that. Men on men horseplay. A lot of times it involves horseplay where one individual is singled out, maybe to be the recipient of those practical jokes, and that can give rise to harassment claims in the workplace, and they are recognized by the law. It's also important to note that the law requires an employer to protect its employees from harassment by third parties. So those they come into contact with during the course of their duties, we need to protect them. So a client, a parent, the FedEx man, if you observe or are experiencing harassment from any of those parties, that's not okay, and we need to know about it, and we will take action. It's also important to know that harassment is viewed from the eyes of the beholder. So it's not whether you think it's offensive, it's whether the recipient thinks it's offensive and whether it's unwelcome to them. And so if you think someone might be offended around you who's hearing this, then keep it to yourself. That's just a good rule of thumb. Use good judgment, model good behavior. And again, if you think somebody in your shot may think it's offensive, don't say it. Yes?
Bullying.
Bullying can be a form of harassment. Technically, and every year the legislature considers adding just plain bullying, whether it's because of membership in a protected class, as a unlawful labor practice. It isn't, but if the bullying is because of membership in a protected class, it's considered unlawful harassment. But bullying isn't okay anyway, whether it's unlawful technically or not. Bullying is not acceptable in the workplace. And I don't know if you have a bullying policy right now, but yeah.
I do want to, let me add something.
Can you hear me? If I swallow the thing, you can hear me, right? So again, this time I'm not going to call somebody up, but this is a real issue in the organization. There has been a presumption that because for years we were lots of women in the organizations, we didn't have these issues the way other organizations do. In the last year or so, our percentage of men has increased to 15% of the organization. Actually, it's 17% now. We've hired a lot of guys. That has brought its own interesting set of problems. The last sexual harassment claim that I dealt with in this agency that ended up in a settlement was a female on male sexual harassment. So don't assume that you're exempt from it out there in your workplace because of the composition of your workplace. It exists all over the place, and we're not going to put up with it, and if anybody is engaged in it, they're not going to be here anymore. But it is a real issue, so watch out for it.
Another thing is using company systems. We put computers on everybody's desks, everybody has emails. Don't use company systems to receive or transmit material that may be deemed offensive. You get that off-color joke from your best buddy, don't forward it to everybody on your distribution list. Keep it to yourself, okay? And I've definitely seen this, and unfortunately with the use of email, it never goes away. If you hit that delete button, it's never really deleted. So it's usually the smoking gun in these types of cases, so just don't do it. And if you receive an email communication you find offensive, go tell that person to knock it off or report it to your supervisor. Yes? The question is, what about personal Facebook posts that might relate to work? That potentially is an issue. If an employee is using their own personal Facebook to harass another coworker, we don't want that. And the employer can take action if it can be connected to the workplace. So whether it's on duty or off duty, if you're using Facebook to harass another employee, we're gonna stop that, and it needs to be reported. So everyone bears responsibility for maintaining a harassment-free workplace. If we don't know about it, we can't do anything about it. So if you see it or experience it, we want you to report it. And all complaints of harassment will be investigated. We'll collect the facts. We'll make an assessment about whether the policy was violated or not. And sometimes when we investigate, it's not, it's a misunderstanding. But we're going to collect the facts. We're not going to prejudge. But if we find there's been a violation, we're going to take appropriate remedial action, corrective action. And that can be a broad range. It can be counseling, it can be a warning, it can be termination if it's a severe circumstance. But that's what the company, that's what Neighbor Impact will do when they receive this type of complaints. We also prohibit retaliation against people who bring forward complaints. So rest assured, if you're experiencing it or you see it and you make a good faith report, you are protected. We're not going to allow retaliation. And the same is true if you participate in an investigation. You're a witness and you're asking questions about the complaint. We're not going to permit retaliation for your assisting in that investigation. I also want to point out that most people think, well, that's just my employer's problem. You know, they'll get sued and I'm scot-free. We're seeing more and more now that the harasser is being sued individually. Personal liability for assault or intentional infliction of emotional distress. So it's not just the Neighbor Impact's problem, it can be your own problem if you are found to have engaged in harassment. So now to move over to discrimination. Yes?
Can I just touch on one thing that you said before? Just because there's probably a lot of people in the room. Well, we had 2 detectives come to our door in La Pine, and I was so grateful for those. Okay. We had 2 detectives come to our door at La Pine, and I was so grateful for those locked doors, because in prior years they could have just walked right in. One guy was really tall, one guy was a little shorter, and boy, were they hot. I mean, they not hot like that, but I mean, yeah. You guys, I mean, they were coming to talk to a child. They were walk in the door and talk directly to a child. And I happened to see these guys from the kitchen while I was doing dishes. I saw 2 gentlemen hovering around the door, and I walked over and I said, you know, very pleasantly, oh, can I help you? And one guy looked at me very sternly and said, you know, I need to talk to, we mentioned some, you know, the child's name and everything. And I'm like, you know, automatically, I'm like, what? And so then they proceeded to, you know, kind of force, like, we need to enter this door. And so I said, well, who are you? And they told me who they were. And I said, do you have identification? And this guy just flashed his badge. He didn't even give me any ID. He just goes, oh, I'm so-and-so. So I said, well, you know what? I'm going to get some help. I'm going to find someone, and you are going to wait over there. And I told him to wait over by the couch, away from the door, because, man, they were ready to come in. So I just want to let anyone know that those locked doors are there for our safety also, and for the children's safety. And I was just grateful for that, and never let anyone in to intimidate you and let themselves in the door, even if you mean well by it. So get your supervisor, and I got the teacher right away, and then we dealt with it, so. Great.
Thank you. Thank you.
No, they're not always appropriate or nice either, yeah, like Denise, yeah.
If in doubt, put them in the waiting area, send them to the parking lot, and make the calls to protect the kids and families that you guys serve. Because sometimes they don't have the authority, but they may represent that they do. And someone carrying a badge can be pretty intimidating. But it won't hurt if they have to wait 20 minutes or get sent away and come back with a subpoena. You're just doing what you need to do in that situation. So I'm going to move on to discrimination, which is related somewhat to harassment, but Neighbor Impact has an equal employment opportunity policy, and it is committed not to discriminate in the terms and conditions of employment based upon membership in any protected class. And it's like the harassment, and it's important to point out that the list of protected classes grows virtually every year that the legislature, either the federal or our state legislature is in session. They add protected classes. Our recent one a couple years ago was sexual harassment and gender identity was recently added. Genetics was recently added as a protected class. So the current list of protected classes are race, color, national origin, citizenship, gender, pregnancy, family relationships, marital status. Can't ask people if they're divorced, single, or married, veterans, military service, sexual orientation, gender identity, age. In Oregon, most people are familiar, federal law, you can't discriminate if you're 40 or older. In Oregon, you can't discriminate based upon youth, unless there's some statute that says that they're too young to perform that particular function. Disability, both mental and physical disabilities are protected. Religion, religious practices are protected. And then finally, genetics. You can expect that list to grow. It's also important to point out that the non-discrimination rules just don't deal with employees. It also deals with the clients that you serve. We can't deny services or condition services, the provision of services we provide to the public based upon membership in a protected class. Excuse me. So you can't deny those services simply because someone is in a member of a protected class. And you also really need to be careful about the kind of inquiries you're making of clients or employees regarding the protected class status. You can't ask those questions, particularly with your clients, unless it's directly related to the services that you provide. So for example, you can't, a client comes into your office and you say, oh, you have a funny accent, where are you from? It's happened. Obviously, then you're asking about national origin or potentially citizenship. That's not information that's relevant in providing those services. Or, why are you in a wheelchair? Not an okay question. Yes, ma'am.
So, can you ask if somebody's married, if it's, like our applications, we have to financially qualify the applications, and we need, if the parents are married, then we need income from both.
If it's information you need for processing their application, yes, if marital status is a factor.
Okay.
Yeah, if it's a factor, but for employment purposes, it's never going to be relevant, but for the provision of services, it may be. But it's always worth scrutinizing your application process and say, is this an absolutely something that we need to know to provide the services? If not, take that question off the application, because simply asking the question, if it's not a proper question, is an illegal act. And the presumption is you may have relied on that answer in providing services. So it's best to steer away from that. And even well-intentioned comments or questions, or maybe an attempt at humor, joking about a protected class or making some kind of comment, it can be used against you in the future. So just be very careful and cognizant of what you say. Certainly in email, but even verbally, in terms of making any type of inquiry into any protected class membership, or making, a joke that may not be very appreciated by the person who's hearing it. With respect to discrimination, an aggrieved party, either an employee or a client, can take action. They can file a complaint against the organization and also any individual who's deemed to aid and abet unlawful discrimination. So there's organization liability, and there's also potential individual liability. I'm going to switch gears here now and talk about some of the activities that you may want to engage in that may jeopardize neighborhood tax exempt status as a 501c3. I'm going to first talk about lobbying briefly. You can't lobby, Neighborhood Impact can't lobby, and we would lose our tax exempt status if we did so. Lobbying is defined as attempting to influence legislation, and that includes anything from Congress, any state legislature, any local council, or similar governing body with regard to any act or bill or resolution. or lobbying with respect to any public referendum or ballot initiative or constitutional amendment. So we can't be involved in those activities at all. It does not include actions by the executive, judicial, or administrative bodies. With respect to the lobbying activities, an organization will be regarded as attempting to influence legislation if it contacts or urges the public, like your clients, to contact members or employees of the legislative body for the purposes of proposing, supporting, or opposing legislation, or if the organization advocates for the adoption or rejection of legislation. So anything having to do with legislation or referendum process, we can't go anywhere near even being viewed potentially as lobbying or advocating for a particular position.
I don't want us to take that too far, however. We can't lobby, but we can educate, and you still have First Amendment rights. So here's how that works. It's perfectly okay for you to say, even to a legislator, Head Start is a good thing for kids. Home ownership counseling helps strengthen communities. What you cannot say is, therefore you should reauthorize the Head Start Act. Or, therefore you should reauthorize the Community Services Block Grant Act. When you get to the point where you start mentioning specific legislation or specific appropriations, that's where you cross the line. You haven't given up, however, your right to an opinion about the work that you do. And I don't want to de-emphasize that we can stand up and be proud of the work that we do, and we can tell other people who matter, as well as people who don't have a vote, that what we do really matters and that the world would be a sadder place if we weren't all here. Okay, got that?
That's a good point, and you'll see in the materials too that you can involve yourselves in issues of public policy. You can provide information, you can educate, you can hold educational meetings, distribute educational materials, or talk about public policy in an educational manner, in an informative manner, as long as you're not taking sides and not jeopardize your tax exempt status. And so that's a good role. You can, as Scott mentioned, these are the great things that Head Start provides or any of your other programs, as long as you're not connecting it to any piece of legislation and advocating for opposition or support of that particular bill. Moving on now to the political campaigns. As a 501c3, Neighbor Impact is also prohibited from directly or indirectly participating in or intervening in any political campaign on behalf of or in opposition to any candidate for elective public office. And this would include contributions to a political campaign or public statements of support, verbal or written, made on behalf of the organization in favor of any candidate for public office. Certain activities are allowed though, again, in that educational component. You can voter education activities such as public forums or publishing voter education guidelines are permitted. As long as they're conducted in a nonpartisan manner, you're not implying or you're not biased towards one candidate or another. You're also allowed to encourage people to vote, to exercise their right to vote, and to participate in voter registration drives and get out the vote drives. Again, as long as you're doing it in a nonpartisan, non-biased manner. What isn't in your materials, and I'm going to touch briefly on now, got added, is the Hatch Act. So this deals with you individually. The Hatch Act does talk about employees and as a private nonprofit organization that plans, develops and coordinates federal Head Start and community service block grant programs. As employees, you are subject to the Hatch Act, and this Hatch Act prohibits employees from using their official authority to influence or interfere with or affect the results of an election or nomination, or to directly or indirectly attempt to coerce, command, or advise a state or local officer or employee to pay or lend money or their name or contribute anything of value to any party, committee, organization, agency, or person for political purposes. This act generally applies more to federal employees who are using their position to influence this process, but because of your participation in Head Start and community block grants, you are also covered by this law. The good news is this really governs what you do in official capacity. And so there's lots of things you can do in a personal capacity. You can obviously vote, register and vote as you choose. You can assist with voter registration drives. You can personally express your opinions about candidates and issues. You can donate to political campaigns. You can join a political party and do everything, but you have to be doing it as a private citizen. And so you don't want to be going to that political campaign wearing your neighbor impact button. You don't want to use company resources, the fax machine, the email, the phones to be engaging in that activity. And you don't want to be doing it on work time. So if you are politically inclined, you can do so, but you need to make it clear you're doing so for yourself and not on behalf of the organization. Really important to make that distinction. The penalties are pretty severe. The employing agency, namely Neighbor Impact, will have to fire you for engaging in activities that are in violation of the Hatch Act, or they have to forfeit a portion of their federal assistance that's equal to 2 years of your salary. Yes?
What's the dividing line of work time and personal time for a salaried individual?
The question is, what's the dividing line between the work time for a salaried versus an hourly employee?
No. If you're a salaried employee, you're not hourly, therefore you don't have a clear definition of what's work time and personal time.
That's true. If you're salaried, you're kind of always working. Or at least your salary is compensation for basically working. But there's going to be times where you're not working, where you're not acting on behalf of the organization. You're at home. And again, if you are salaried and you're a supervisor, unfortunately you wear that hat wherever you go. People associate you with a supervisor, manager, Head Start, so you need to make a bigger effort to say, hey, I'm here on my own time, this is my personal opinions, they don't represent the opinions of the organization, and take greater care in making sure people understand that you're not here in an official capacity, because as a manager, you're always a manager for Neighbor Impact, or that's the perception.
So where this comes into practical application is we're coming up on the primary season, which will be in May, and we're coming up on the general election in November, and things always get crazy, as you know. So a couple things will happen during that time. First